You know, it occurred to me that one of the reasons I started doing this TikTok channel was to answer the not so dumb questions of family law. And even now, I don't know how long I've been doing this, and all the people that you kind, lovely people who follow me, one of the questions I still get asked again and again and again is kind of what really happens in family court. So that got me thinking. So this video is for all of you. So I'm going to give you the top 5 things to realistically expect in family court. These are in, by the way, no particular order. Number 1, delay. Oh my God. If I say one more time to a client, chase the court, chase the court. Did I mention chase the court? Chase, 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 chase. Be the squeaky wheel. From the moment you put your application in, whether that's financial or child, by the way, there is what feels like a massive delay between putting your application in to actually getting your first hearing. And depending where you are in the country, that delay can be even greater, and in some instances can have quite an impact on your child. Now, I'm not going to name any names for courts here, but some of the bigger courts, it's a numbers thing, I get it. Some of the bigger courts often have greater delays. And if you ever try and get hold of any of these bigger courts, you will probably adding some grey hairs to your life, taking annual leave, and generally being frustrated. I know, I get it. I have the same frustration, because when people come back and say to me, I have been calling and calling and calling and I still can't get anywhere. I mean, who picks up the phone? I get it. So there's a massive level of frustration. So delay is going to be one of the key things that will, if you weren't stressed out before, you're sure as hell going to be stressed out after not getting through to your court. Number 2, missed deadlines. Oh my gosh, if I hear one more time, the ex hasn't put their statement in, they were due to put their statement in, or they were basically they were ordered to file X, Y, and Z by a certain date, and shock, horror, mock shock from me, they haven't put it in. It's a thing. Ever seen that? You've seen the film The Pirates of the Caribbean. There's a famous quote I always put into here, and that's, they're more like guidelines. So shock factor, courts don't have any sanctions really for people that miss deadlines. It happens all the time. And that can be particularly frustrating if you're on a tight, so finance falls into this really nicely. If you've got like a finance case, there's always like a massive to-do list. Documents have got to be filed by certain dates, and it's really frustrating by the time you get to your first hearing and a whole bunch of documents haven't been put forward to the court. And the whole point of having that first hearing, the whole point of having that to-do list from the court is to have cards on the table, so the court and the other and both of you know what you're working with. So that's really frustrating. You also might be in that position where you're scrambling around. It's lastminute.com. I know, because some people reach out to me at lastminute.com and said, oh my god, my statement needs to be put in by such and such and such and such a date. So I never tend to get out of my tube about it either, because like I said, there's no sanctions from the court. Of course, if it's perpetually late, and I've seen people that do this quite often, that can be a factor that the court might use. But don't expect the judge to look over their sort of their half-rimmed glasses and go, tut, 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 you didn't file that statement on time, because it just doesn't happen. Number 3, allegations of abuse. Every case has them, which, I don't know, I feel really blasé saying that, because, you know, I deal with both sides of this fence. I'm dealing with people who have allegations of abuse levied against them, and also I deal with people who genuinely have allegations of abuse against their ex. So I see both sides of this fence. But whether you're giving or receiving, sounded so wrong, and there are going to be allegations of abuse, and the court will have to work out to deal with them. And by the way, that also factors in finance as well. I mean, conduct under Section 25 of the Matrimonial Causes Act is a factor that looks into. Thing is, when a couple separate, trust and communication have gone, and you probably will have ended a relationship, whomever ended the relationship, on not so great terms. So there's going to be a reason for that. So whether if the person receiving allegations of abuse, and you're saying, look, this just didn't happen, the ex is just trying to manipulate the system to do A, B, and C, or whether you're the person that says, no, actually, you know, I was a victim of domestic abuse, this absolutely happened, and I need to protect me and I need to protect my children. Either way, I have yet to come across a case that doesn't, especially in child matters, that doesn't have allegations of abuse. So that is definitely real tea. Number 4, I don't care how you dress this up, it's going to cost you something. Whether it's a court application fee, so it's 232 for a C100, it's going to cost you something. And even if you're representing yourself, so fun fact, 70% of people who go through family court do represent themselves. But at some point, somewhere along that line, even if you are representing yourself, even if you are doing it completely on your own, and of course you're watching videos like mine, or whether you're on Google, doesn't matter, at some point you're going to need help in putting together statements. Now, I know some people have gone through all the way, and kudos to you, because this is a frustrating and very stressful thing to go through. You're not going to get anything more emotive than your children. So for you, you are living and breathing this. Now, there absolutely is a power of representing yourself. Hey, I've been helping people representing themselves the last 17 years, and there absolutely is a power in that. But my point is somewhere along the line, you're going to struggle, whether it's a statement, whether even from the beginning, whether it's form filling. People represent themselves. One of the things they do is that they want to give the court everything. It's like they want to give them the kitchen sink, everything, because this is your life and it has to be resolved. And why do they not want to know X, A, B, and C? So sometimes you guys can't see the wood from the trees because this is emotive. This is your children. So somewhere along the line, it's probably gonna cost you something. So just be prepared for that. And don't forget, if you're represented, the average cost of a solicitor, and I'm sort of setting aside people who've got legal aid here, obviously, but even then, actually, so some of the people who use me that have got legal aid often aren't that great. Kudos to you if you've got a great legal aid solicitor, but very often I find that the legal aid solicitors tend not to be proactive. There's no kind of joined up thinking. There's not always strategy. And people often feel disempowered by them. So, guys, I still get people who have me for meetings doing paperwork, etc., because they're not so happy with their legal aid solicitor. So, and by the way, the average cost of a solicitor just generally is £250 an hour plus VAT. More if you're in a bigger city. So if you're in London, it tends to be more. Hashtag if you know, you know. That's a lot. That's a lot. So just know that you have options out there. Okay, but at some point it's going to cost you. And finally, number 5, courts don't enforce their own orders. Boom. So whether the ex has breached a court order, you're there rushing with your enforcement application to the court and thinking, hang on, why are they not doing anything? Or why are they not doing anything off their own volition? So it's often a bit of a killer when people say, I can't believe the court has made an order and they're not enforcing it by themselves. And even when you do make the application, sometimes they still maybe get a slap on the wrist. It's not always the way to go. So this is absolutely for another video, because I can feel a rant or a soliloquy coming on. But if you don't put that enforcement application, you're actually silently complicit to what the other side are doing. Breach contact, no problem. I'm not going to make an application. So sometimes just making the application can be quite strategic in voicing your opinion. I get it. It's a bit of an expensive way and a long-winded way to go, look what they're doing, look what they're doing. But this is real tea. What happens in a law book, I know, I've studied them, doesn't always relate to what happens in a courtroom. It's a bit like driving, the theory, what should happen, but who indicates? You're pulling out of a roundabout and you're thinking, could you not have indicated? So what happens in a textbook doesn't always marry up. Pun? I think kind of intended. Doesn't marry up to what happens in a court scenario. Let me know down below in the comments, what have I missed?